Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate and a corporate lawyer. In today's class, we will discuss two important judgments which are in the favor of accused, means a charged official, and before proceeding further, we have to understand the basis of law point. If there is a case against you under Prevention of Corruption Act, there is a possibility that department may initiate action against you on ground that by your act the esteemed image of the department had been affected and you might be prosecuted as per CCA rules. So in that scenario, what to do and how to proceed further? Please be noted. If there is a case against you under Prevention of Corruption Act, which is sub judice, means pending, till conclusion of the proceeding of the case under Prevention of Corruption Act, the proceeding in nature of departmental action, if based on same ground, would be illegal and abuse of process. First of all, we have to note down the important judgment of Honorable Rajasthan High Court, that is Devendra Mehta versus Union of India. Judgment date is 12th of January 2022. In that case, the concerned official was associated with central government. He was trapped and finally charge sheeted as per the protocol of Prevention of Corruption Act. In the meanwhile, department had served a show cause and finally the memorandum of charge and all the proceedings had been challenged by the concerned official on ground that I am already having a case under Prevention of Corruption Act. On the same grounds, departmental action had been initiated which is going to prejudice me and my rights. The prime reason accorded by him was that in a criminal case, the accused is not bound to disclose his defense. But in departmental action, if I am not going to submit a reply, in that scenario, adverse action might be taken against me. And inter alia, if I submit my reply, my defense will be on board and inter alia, serious perjury will be caused to me. So looking to the facts and circumstances, remedy was inclined in favor of charged official and proceedings are directed to be stayed, which is commonly called the proceedings are required to be kept in abeyance. So basically, the said scenario is a legal concept. Stay is basically a general concept, and in the legal concept, it is termed as the proceedings are required to be kept in the abeyance. Please be noted, judgment number 2. Judgment pronounced by Honorable Punjab and Haryana High Court. Title is Joginder Kaur versus State of Punjab. Petition number is 22263/25. Judgment is pronounced on 12th of August 2025. In that case, the official was charged under Section 7 of PC Act, read with Section 308 of BNS. A writ petition was submitted before the Honorable High Court as per the protocol of Article 226 of Constitution of India with a prayer. The direction is to be issued to the concerned respondent department to keep the departmental proceeding in abeyance. And finally, the plea was accepted and direction was issued. So basically, the said to judgment says that if we are having a case under Prevention of Corruption Act and on the same ground there is a departmental proceeding, the departmental proceedings are required to be kept in abeyance till conclusion of case under Prevention of Corruption Act. You got the point now? So basically what to do if you are having the same trouble? So in case a notice was served to you, which is called a show cause notice, simply you have to reply with legal position that the proceedings are not maintainable because if a case is pending under Prevention of Corruption Act, till conclusion of that case on same ground, departmental proceedings are barred. If you will initiate, definitely serious prejudice will be caused to us or me. In that scenario, we would be left with no option, or I would be left with no option except to proceed before Tribunal or Honorable High Court for vindication of grievances. Please be noted, the prosecution knows the fact and defense know the law. You must be able to understand the legal position. Otherwise, on factual score, you would be defeated. They might impose liability on you by saying that you are corrupt and you have done wrong. But legal position is in your favor. It says that if case is pending till conclusion, the concerned vigilance or CBI charge sheet cannot be a basis of departmental action. If the proceedings are initiated, it is required to be kept in the abeyance. So in that scenario, simply submit the representation. If it is not considered, you may approach before the Honorable Tribunal or Honorable High Court as per the available remedy. Please be noted, if the remedy alternative is available, do not move for a writ petition, because if remedy alternate is available, in that scenario, writ would not lie. So if you are having a remedy before tribunal, move before tribunal. And if you are not having any remedy before tribunal, then you may move before Honorable High Court. So I think that I am totally able to cause all of you to understand the basis of legal position to protect your rights from being vanished. See you in the next video. Till then, Jai Hind, Jai Bharat.